Members of the jury, what you're going to learn during the course of this trial is that back on January 13th of 2014, Chad and Nicole Oulson decided to spend the day together. It was a Monday. They had not been spending that much time together based on their work schedules. They were also raising their daughter Lexi, who at the time was just under 2 years old. So they decided on that day that they were going to put Lexi in daycare and go out for breakfast, possibly shopping, maybe over to Wiregrass. And eventually, at some point on January 13th, they decided to go to the Cobb Grove Theater. They were going to see the movie Lone Survivor. That was going to start about 1:20 in the afternoon. Now, that's located at 6333 Wesley Grove Boulevard in Wesley Chapel here in Pasco County. So what you're going to learn is that they go to the theater. When they get there, they purchase their tickets. They then go inside to the concession stand and they buy some snacks. After that, they decide to go into the theater. Now, this theater is theater number 10. And what you're going to learn is that theater number 10 is a Cinebistro. It's a general theater and a Cinebistro. And you may know what a Cinebistro is, but basically it's an area of the theater where you can order food kind of like in a restaurant setting. You don't have to go to the concession stand. And this particular part of theater number 10 is separated from the general theater by a wall. In fact, there's a separate entrance. Now, what you're going to learn is that when Chad and Nicole Oulson decided to go into theater number 10, they were looking for some seats that were towards the back of the theater. That's where they like to sit. So they chose the row that was to the second to back last row. And they went over towards the middle. Nicole Oulson sat down, and on her right was Chad Oulson. Now, at this point in time, there wasn't that many people in the theater. People were still coming in. They had their snacks. They were talking. And at some point in time, one of them, doesn't matter who, one of them wanted some more snacks of some type of candy. Chad Oulson gets up, leaves the theater, goes back to the concession area, and of course, more and more people are coming into theater number 10 to see the movie. When Chad Oulson comes back, he sits down. Again, he's still on Nicole Oulson's right. And at some point in time during this, the defendant and his wife, whose name is Vivian Reeves, comes into the theater. Now, when they come into the theater, they decide to sit in the very back row. Now, there's a wall behind them because behind that wall is where the Cinebistro area is. They go to the very back row, walk all the way across to the middle, and they sit down. Now, to kind of paint a picture for you as to where everybody's seated, and you're going to see this in video, and people are going to tell you where they were sitting. Picture this. So, in the very back row, you're going to have the defendant. He's sitting in the middle. Directly in front of him is Nicole Oulson. To Nicole Oulson's right is going to be Chad Oulson. Behind Chad Oulson is the defendant's wife, Vivian Reeves. So stated another way, to picture it a different way, you have the defendant in the very back row, basically in the middle. An entire row in front of him and an entire seat over to the right is where Chad Oulson is sitting. That's the layout of the theater on this particular day when this shooting occurs. Now, what you're going to learn is that there were many people that came into the theater. In fact, at the beginning of jury selection, a long, fairly long witness list was read to you. And you heard from the court and you heard from us that you're not going to hear every single witness that's on that witness list, because there was a fairly large law enforcement response, and not everyone in the theater has relevant information. Some people became aware of the shooting afterwards. Some people didn't see anything. Some people didn't hear anything. And some of the law enforcement officers were there for basically security. So you're not going to hear from every single person. The people that you are going to hear from, they have different parts of the whole picture, meaning this. Some of the witnesses that you're going to hear from heard the beginning of what happened. Some heard the middle, some heard the end. Some saw the beginning. Some saw the middle, some saw the end. Some heard and saw basically everything. Now, you are going to learn that there is a video. And by video, I mean just that. There is a video and not an audio. The video comes from the Cinebistro area. There are two cameras inside of theater number 10 on opposite sides of the theater. Now, they were designed, as I mentioned, to capture the Cinebistro area, but they did capture some of the general part of the theater and did capture this shooting. Did capture people coming in the theater, did capture people leaving the theater, the defendant leaning in and talking to Chad Oulson, things of that nature. The video did capture that. Again, there's no audio. The audio is going to come from witnesses. Now, what are you going to learn? Well, people are going to tell you what the lighting environment was. So people in the theater are going to tell you the following. Now, don't pay particular attention to any single one-word description because you can't adequately describe something in one word. In other words, to be pigeonholed to one word. For example, in everyday life, if someone were to tell you that someone was of a medium build, well, one person might think of that as a thin person, and another person might think of that person as a heavier person. But the description, when people elaborate, that's how you're going to be able to determine exactly what happened. So in this case, what are you going to hear from people that were in the movie theater? You're going to hear that at the time of the previews, now, this shooting occurred during the time of the previews. So when I talk about the lighting conditions, it's the same during the time of the shooting. So what witnesses are going to tell you is that it was light enough for them to see in the movie theater. The lights weren't full, they weren't full house lights. It had been dimmed. So if you hear the words dim, dimmer, pretty dark, darker, that sounds like it's painting a different picture, but I submit the evidence is going to show you that when everyone came into the theater, their overall description, forget the one word, was that they could see. They could see aisles, they could see rows, they could see seats, they could see people in those seats, even at a distance. They didn't have any concern during these previews. Again, this was the time of the shooting, that they needed a flashlight or their phone to offer some light for them to navigate in the theater. It wasn't dark like when the movie starts. That's the lighting conditions at the time this shooting takes place. And that's the lighting conditions you'll learn about when Chad Oulson is on his phone. Now, what happens? The previews start. People are seated inside the theater. Again, you have the defendant in the very back row in the middle. In front of him is Nicole Oulson. Over to her right is Chad Oulson. Behind Chad Oulson is Vivian Reeves. The previews start, and there is a message that you should turn your cell phones off, basically. Now, here's what you're going to learn. Chad Oulson had his cell phone on. Now, by on, this is what I mean. Chad Oulson, the evidence will show you, he's not talking on his phone. He's not conducting a business transaction. He's not talking to a friend, a family member, not having a loud conversation. By on, literally the phone is on. That's it. The evidence will show you that there was a white light coming from the phone. That's how the phone was on. You're going to learn that almost immediately or very close after the time of that message, please be responsible, turn your cell phone off, whatever the message is. Very close in time to that, without really waiting, the defendant over here leans in to Chad Oulson and Nicole Oulson, because the evidence will show you the cell phone had a light on it. Now, what you're going to learn is that this defendant leans all the way in, and it's going to sound silly when I say this, to Chad Oulson's personal space. And you're going to see this on video because it's captured. Not only is a witness going to talk to you about it, but it was captured on video. The defendant leans all the way in from his seat and basically gets back to the left ear of Chad Oulson. So the defendant's head is basically in their space. You're going to learn from a witness that the defendant's tone was kind of demanding. Turn your cell phone off. Now, at that point, the evidence will show you they're kind of taken aback by this. Now, Chad Oulson did not turn his phone off. Now, here's what you're going to learn what was going on that phone. He was looking at Facebook. Social media. There was a website that he was looking at through Facebook, and they had been looking at it. The evidence will show you, of course, that's no reason to shoot another man. But here's what you're going to learn. That the defendant leans all the way forward, tells Chad Oulson to turn his phone off. Chad Oulson doesn't turn his phone off right away. Now, in a perfect world, should Chad Oulson have turned his phone off? Yes, but the evidence will show you that you can't kill someone for that. Now, the evidence will also show you this, that the defendant waited a little bit, asked him again to turn his phone off, then got up to leave the theater. Now, the way he left the theater is going to be important for you to consider during the course of this trial. The overall attitude and demeanor of the defendant that's going to be described to you during the course of this trial is very important. Because one of the charges the defendant's been charged with is a crime called murder in the second degree. And all of these laws are going to be explained to you at the conclusion of the case when the judge gives you all of the instructions. But a part of murder in the second degree is that we have to prove that the defendant acted with ill will, hatred, spite, or evil intent. Ill will. animosity, bitterness, spite, annoyance. So the defendant's demeanor and his actions will play into whether or not there is ill will, hatred, spite, or evil intent. So here's what's important about when the defendant gets up to go tell the manager that this white light is bothering him during the movie previews. The defendant gets up, and as he goes out the aisle, he's mumbling to himself. Now, you're going to hear from a witness who's going to tell you that based on her life experiences, he appeared to be agitated and angry. The evidence is going to show you that he was. He was annoyed that Chad Oulson still had that phone light on. And he walks out, he's mumbling to himself. Now, as he's walking out fine, meaning this: whenever anyone navigates through an aisle or a row in a movie theater, you necessarily have to move around people and it's kind of awkward. But he was able to do that. There's a video that you're going to see that shows him getting up and walking out of the theater. People watch him leave the theater. Memories in the back row, goes all the way down the steps. There might be 13 rows. You're going to see pictures, you can count for yourself. Walks all the way down the ramp, all the way to the manager's desk. Now, when he's at the manager's desk, what happens? Well, when he's there, and again, there's no audio, there's going to be just a video, watch his demeanor. Now, I don't mean to present to you, and I'm not painting the picture to you that when he's at the manager's desk, he's banging on the desk and screaming and demanding action, because he's not. But when we're talking about the demeanor of the defendant, the evidence will show you this ill will or spite. Watch his arms, watch his hands, watch his fingers, watch his facial expression. He's there for about 3 minutes, walks back into the theater, all the way up the ramp, around the corner, all the way back up to the back row, all the way across again into the middle. Now, the witnesses you're going to hear from are going to tell you this. They're going to tell you that the defendant did not appear to have any disability. He didn't have a cane, didn't have a walker, didn't have a wheelchair. The evidence will show you, and it sounds like a silly thing to measure, the defendant parked 133 yards away from the theater. Now, it sounds silly, again, it's a football field and a third, but there's no handicap placards. The defendant's not handicapped. Wife didn't have a handicap placard. You're going to see video of the defendant as he purchases tickets. He's in the lobby area, in the concession area, walking to and from the theater. Now, why is that being brought up? Well, the evidence is going to show you this, and we're going to talk more about it in just a little bit. But the defendant gives a taped statement to law enforcement, freely and voluntarily waives his rights, and there's going to be a picture painted during this taped statement. And one of the things you're going to learn in this taped statement is the defendant states he's got arthritis in his back and his knees. Well, the evidence will show you that, let's say that's all true, it's very, very bad. The evidence will show you that's no reason to shoot and kill another person. However, when you see the actual pictures, meaning the video, and you listen to the witnesses, you're going to see he was completely fine. Now, what happens? When he walks back into the theater after speaking to the manager, coming back across the row, now, it doesn't matter exactly when this happens. It's either as the defendant comes back into the theater, as he's sitting back down, or even some seconds after he's fully seated in his seat. Doesn't matter. But the defendant in this taped statement indicates that he reinitiates contact with Chad Oulson. Now, what's the evidence going to show you in this case? Chad Oulson was talking to someone earlier, and it was the person in the row in front. At no time will the evidence show you that Chad Oulson is volunteering to talk to the defendant. The defendant's always the one initiating the conversation. And as the defendant comes back, based on his own statement, he indicates that he reinitiates contact with Chad Oulson and tells him this. And here's something that's important you're going to learn during the trial. Chad Oulson did, in fact, turn off his cell phone. The phone was off when the defendant came back into the theater. The evidence will show you that the defendant could have just sat back down in his seat and everyone could have watched the movie and everything would have been fine. The phone was off, no problems. The evidence will show you that after there's a conversation, Chad Oulson is in his seat. Now, what the defendant states to Chad Oulson is, I see you put your phone away. I told the manager for no reason. Now, I submit the evidence will show you that there was no reason for that. Regardless, the statement was made. Based on the defendant's own statement, Chad Oulson turns around in his seat. Now, when you listen to the defendant's taped statement, pay very close attention to the words he chooses to use and the order in which he uses these words. The defendant states Chad Oulson turns around in his seat, and now Chad Oulson says some words to him. Now, in a perfect world, should that have happened? No. The evidence will show you can't shoot someone for that. Chad Oulson does turn around and starts to have some words with the defendant. Mind fairly quickly. It's fluid. Chad Oulson stands up and continues, and he looks at the defendant. Chad Oulson's in his row. Remember, he's an entire seat in front of the defendant. An entire row in front of the defendant, and an entire seat over. And during this conversation, while he's standing up, he says, if it's any of your business, and they're Zillow, buying a car, buying a house, checking the stock market, Facebook, texting, you can't shoot and kill somebody. It's irrelevant. I submit the evidence will show you he was just trying to get the defendant to leave him alone, and that's what he chose to say. Really doesn't matter. So the evidence will show you this. Chad Oulson is standing up. And as he's standing up facing the defendant, and you will see this on video, Chad Oulson reaches over with his right hand. And he reaches over into the defendant's lap and he grabs something. Now, this might sound silly. What does he grab? Does he grab a deadly weapon out of the defendant's lap? The evidence will show you absolutely not. Does he even grab a big tub of heavy popcorn? No. Here's what you're going to learn during this trial. Chad Oulson reached over with his right hand into the lap area of the defendant and grabbed a bag of popcorn. And he grabbed that bag of popcorn and he brought it back and he flicked it at the defendant. Now, the evidence will show you, of course, in a perfect world, should Chad Oulson have grabbed a bag of popcorn and tossed it on the defendant? Well, of course not. The evidence will show you can't shoot and kill another person over that. So the evidence will show you this, because there's a couple of things happening simultaneously at this point. So I want to break it down just a little bit. Chad Oulson stands up. He's facing the defendant, says something about texting his daughter. He reaches over, grabs the bag of popcorn, and flicks it. Doesn't pull it back, isn't using it like a bat, just flicks the popcorn on him. His hand is now coming back. At about that very same time, Nicole Oulson, remember, she's sitting in front of the defendant. She's starting to reach over with her left hand while this is happening. And in the process of getting up to say, honey, it's just sit down. So her hand's up. When her hand is up, and while Chad Oulson's hand's coming back from that popcorn toss, this defendant shoots. So taking a step back to kind of go over what happened, the evidence will show you Chad Oulson is sitting in his seat, turns around, says a few words to the defendant. Stands up, says a few words to the defendant, reaches in, grabs the popcorn, flicks it. Now, this is important to watch on the video because it goes back to arthritis, my back, my knees. What you're going to see on the video is the defendant, in an incredibly quick and swift maneuver, reaches his right leg out as he's leaning back, goes into his pocket to get his firearm that he's brought into the theater, pulls it out, and lunges forward to shoot Chad Oulson. The evidence will show you he's not back cowering in fear, but watch the manner in which he grabs this firearm, how quickly he is able to do it, how fluid he's able to do it, and how he lunges forward as he shoots. And why is that important? Well, to go back to the instruction of ill will, hatred, spite, or evil intent. The evidence will show you he was mad. Chad didn't listen to him, and Chad threw popcorn on him. So what happens next? After that, Chad stumbles. He begins to turn to go towards the aisle. He goes down a couple of seats. He's shot in the chest. He can't make it to the aisle even. He falls down on other people in the theater. Nicole Oulson's finger is almost shot off. It's almost severed from the bullet going through. She's screaming. Chad falls on the ground. There happened to be nurses and other people there that tried to help Chad Oulson as he's laying on the ground with that bullet in his chest. Now, ultimately, of course, Chad Oulson dies. He's basically dead in the movie theater. There happened to be an off-duty deputy, not from the Pasco Sheriff's Office, but from another county in the theater. He gets up, you're going to see this on video, and he walks over to the defendant. The defendant has his gun on his lap. It's taken from him. The gun eventually is given to a sergeant at the Pasco Sheriff's Office. That gun is eventually sent to a place called the Florida Department of Law Enforcement. Now, during this trial, there's going to be some stipulations. Stipulations are agreed upon facts, so to speak. You get these, there's not going to be any other testimony on the matter. They're basically just accepted to. Now, one of the stipulations you're going to learn is that this firearm, the one the defendant used, it's a .380, was sent to the Florida Department of Law Enforcement. There's a shell casing there. Shell casing came back to that gun. Now, that's not an issue in this case because this is not a whodunit case. The important part of that stipulation is that this firearm, the one the defendant brought into the theater, was working properly. Didn't malfunction, wasn't an accidental shooting. This was an intentional and purposeful shooting. The gun was working fine. Now, people are working on Chad Oulson. This other deputy is with the defendant. People call 911. Now, you can imagine when there's a 911 call about a shooting in a movie theater, there's a fairly large law enforcement response, and there was. And this is when the investigation begins. Now, people that were in the theater, they go to different parts of the theater. Some are in front of the screen, some are in the concession area, the lobby. Now, fire rescue was called. They had to what's called stage, meaning they had to wait for the movie theater to be secured before they could go in to try to help Chad Oulson. When the deputies came in, they made sure the scene was secure. They were trying to help Chad, dealt with the defendant. Fire rescue comes in, everyone goes to the hospital. Chad's life can't be saved. Eventually, Nicole has work done on her finger. Now, while deputies are there and people are in different parts of the theater, they hand out these blank forms. And sometimes they're called written statements. And people are not given any instructions on how to fill these out. They're just told to write down what you know. Now, of course, these are people in a theater who aren't law enforcement officers or lawyers, and they don't know how much to write or how little to write. Some people write one sentence, some write 10 sentences. It's basically just what they saw. Some people are going to tell you they're really upset by what they saw. And law enforcement used this as a first step in their investigation. Read those written statements, tried to figure out who they needed to talk to in some type of order. Who they were going to talk to that day, who they were going to follow up with later on. That's what happened with the written statements.
Scott Rosenhauser delivering the opening statement for the state of Florida. We need to slip in a break. Back after this, you won't miss a thing. We'll pick it up right where we left off.
Up until the point.
Derek Chauvin, convicted for the murder of George Floyd. Now, the other 3 officers face charges in federal court.
And Court TV teams are live with every update.
Live updates today on Court TV.
We, the jury, find the defendant guilty.
Kim Potter waits for sentencing in the fatal shooting of Dante Wright.
The mistaken taser sentencing. Live coverage Friday, 10/9 Central on Court TV.
Did you know that you don't have to be 65 years old to qualify for
Written statements, some people were near them, but no one was telling other people what to write or what to say. The witnesses that come into court are going to tell you what they personally heard and what they personally saw. That's it. Now, witnesses were interviewed. The defendant himself gave a statement, as I mentioned. He gave a tape statement. What the evidence will show you is that Chad Oulson was shot and killed over tossing popcorn. The defendant's statements are fairly consistent with other testimony and other evidence, including the video, up until the point of time of the shooting. The evidence will show you that the defendant's statement is not accurate as about what had occurred, based on what you're going to view during the course of this trial. So what did the defendant tell the police? The defendant tells the police that he went to the theater. Obviously, he did. While he was in the theater, he saw Chad Oulson had his phone on. Now, the defendant states he leaned forward and was being nice, asking him to turn the phone off. When Chad Oulson did not, he got up and he went to tell the manager. He came back. The defendant says that when he came back, he did talk to Chad Oulson, and he told him the statement that I represented before. I see you're not on your phone anymore. I went to tell the manager. He says, and again, the words he chooses are very important. You're going to learn that he was former law enforcement, so he knows the importance of the accuracy of words. He says that Chad turns around in his seat, and at that time, there's some words between them. He then indicates that Chad Oulson jumps up. Now, here's where I submit to you the tape statement has maybe two different statements, and this is where you're going to have to critically analyze this tape statement. It seems as though the evidence will show you that the defendant states nothing at all about the popcorn in the beginning, as that event never took place. Now, you're going to learn with his glasses on, the defendant's got 20/20 vision. Can't really miss anything. What the defendant states is that Chad Oulson is coming over on top of him. Okay? So when you listen to the tape statement, at first it appears as though the whole popcorn thing never happened. Later in the tape statement, the defendant states when Chad Oulson jumped up, the popcorn fell almost immediately. Well, the evidence is going to show you that after the popcorn fell, that's when this defendant immediately took out his firearm and killed Chad Oulson. So the evidence will show you that tape statement's not exactly true. He says that when Chad Oulson jumps up, the popcorn fell immediately, and this is the picture painted in the defendant's tape statement. Here's what the evidence will show you. The defendant states he's in his seat behind Nicole Oulson, remember. Chad Oulson's one seat over to the right. One row down, one seat over. He's back in his seat, and he's got his left hand up, and he's yelling, no, 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 or whoa, whoa, whoa. This is the picture the defendant's going to paint on this tape statement. And he's back in his seat, and Chad Oulson is coming over the seat, and Chad Oulson is virtually on top of him. In his lap. Those are the words the defendant himself uses. Virtually on top of him, in his lap, and he's got his left arm out, and he's touching his arm or his shoulder, but he really believes he's touching Chad Oulson's chest because he's so far into him, into his row. And at that time, he has to straighten his right leg out, pull out that firearm, and kill him. The defendant states he's surprised he didn't shoot his left hand because his left hand was so far out when he took that shot. He's surprised. The evidence will show you that is not exactly what happened. There will be no witnesses that will come in here and tell you that happened. No one heard any yelling, screaming, any type of fight like that, a life or death struggle. You're going to hear about a term called stippling during the course of this trial. Stippling, and this might be a really bad description of it, is when a firearm is fired, material comes out, hot material, and anything that's close in its way gets these embers, so to speak, and there's a burn mark on skin. Now, you will see stippling in this case. The evidence will show you there was stippling on Nicole Oulson's hand because it was in front of the firearm when her finger was almost shot off. You're going to see stippling on Chad Oulson's wrist because when he brought his wrist back after tossing that popcorn, you're going to see stippling all over there. But the evidence is going to show you there's no stippling on the defendant's left hand. The evidence will show you that's because his left hand was not out. No, 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 you got to get off of me. That's what the evidence is going to show you. Now, after the defendant fires the shot, there's some important words that people in the theater hear. And these are people that don't know each other, and these are people that are in different areas of the theater. And the defendant states some words to the effect of throw popcorn at me or throw popcorn on my face. Yet when you listen to the defendant's taped statement, it never really brings up the popcorn. The evidence will show you that's important for ill will and spite. And when you see the way he lunges forward with the firearm and makes that statement, you get a clearer picture of what was really going on in the theater on January 13th. The defendant states in this taped statement that while he's back with his arm out yelling, no, 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 or whoa, 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 and Chad's virtually in his lap, he's struck on the left side of his face. Remember, you can hear the defendant, prior law enforcement. Words and choices of words are important. The defendant states in this taped statement that he's hit on the left side of his face. Well, witnesses are going to tell you they never saw that. And the evidence will show you that almost scientifically, physically, it's not possible. Because the evidence will show you that Chad Oulson was a row in front and a seat over to the right. And that it would be virtually impossible for him to do this hook that hooked all the way around from that distance across an aisle, all the way across seats, and struck the left side of the defendant as he was all the way back with his left hand out. The evidence will show you that simply did not happen. The evidence will show you there was no injury, as if he was struck that hard, because the defendant in his taped statement, you will learn, says he was dazed. But he wears glasses. You'll see there is no injuries of any markings for glasses of being hit that hard that he felt he had to kill another human being. At some point in the taped statement, the defendant indicates he thinks that maybe a cell phone was at play because he saw the blur of a screen. Now, you will learn that a cell phone was found in front of the defendant, and it was, in fact, Chad Oulson's cell phone. I submit the evidence will show you that it got there in one of two ways. One, because he was holding it in his left hand or his left side, and we know that because that was the side that was bothering the defendant. That when he stood up and he grabbed that popcorn, it fell over. Or at the time he...
Rosenwasser is going through the case with the jury here in the opening statement for the state of Florida. We'll step aside, take a break, and return right after this.
Hi, I'm Mark from the Medicare Helpline. If you're on Medicare, it's time to call to see if you're getting all the Medicare benefits that may be available to you, even if you called last year. Many Americans may be eligible for additional benefits. Your zip code may qualify you for a Part B give-back benefit in your monthly Social Security check. So, call to see if you're eligible for a plan that may include additional benefits. You won't get additional benefits automatically, but listen. I'm here to tell everyone on Medicare it's fast and easy to check up on your Medicare plan benefits.
The defendant being hit with that phone, and there's no possible way that could happen. Now, another stipulation will be about this cell phone. This cell phone was also sent to the Florida Department of Law Enforcement. And there was some DNA testing done on this phone. Chad Oulson's DNA was on the phone, but not the defendant's. Now, you're going to see pictures. The defendant did have some redness on his left eyelid, possibly the most fragile part of the human body. But the evidence will show you he had his glasses on. And the reason that his left eyelid, only his left eyelid, was red was because after the shooting, he was rubbing his face and rubbing his eyes, and witnesses will tell you that. He indicates he thinks there's something in his left eye. Paramedics check him out. There's nothing in there. They do a saline rinse. That's the end of the story. The defendant indicates in his taped statement that he second-guessed himself. He's sitting in the cruiser, and you're going to hear he says, I'm second-guessing myself. Did he hit me? This is the picture that's going to be painted for you during the course of this trial. The defendant also states, and I apologize for cursing, at some point in this taped statement, now, for his actions, the defendant's been charged with 2 crimes. Murder in the second degree and aggravated battery. Now again, all of the jury instructions are going to be explained to you at the conclusion of the case. Now, suffice to say, this is what murder in the second degree is. What we have to prove to you is Chad Oulson is dead. It was due to the criminal act of the defendant, and it was by an act that was imminently dangerous to another, demonstrating a depraved mind. And shooting someone at close range is an act imminently dangerous to another. That's not going to be an issue in this case. Did he do it with a depraved mind? That's where we fall back on the definitions that you're going to learn: ill will, hatred, spite, or evil intent. The other crime that the defendant's been charged with is aggravated battery. Now, going back to murder in the second degree, we do not have to prove to you that the defendant here intended to kill Chad Oulson, just that he intended to act, which he did. This is not a case where it's an accidental shooting. He did intend to shoot him, and he died. We just don't have to prove he intended to cause Chad Oulson's death. Now, aggravated battery, what we have to prove to you is that the defendant did intentionally, knowingly, and unlawfully touch or strike Nicole Oulson against her will. Now, obviously, he didn't do that with his hands. He did that by using a gun and firing a bullet. So it's the same analogy. Did he touch or strike her against her will? And did he use a deadly weapon? Yes, a firearm is a deadly weapon. The other way that we could prove aggravated battery on Nicole Oulson is, did he intentionally touch or strike her against her will? Yes. And cause great bodily harm, permanent disfigurement, or permanent disability? And the answer is going to be yes. You're also going to learn about an instruction called transferred intent. And basically what that means is if one person intended to do an act, meaning the defendant intended to do an act to one person, but ended up harming another. In other words, intending to shoot Chad Oulson, but harm Nicole Oulson, be transferred intent. And that's how we get to the aggravated battery charge. Now, what is this case going to be about? Based on the facts that you were given at the beginning during jury selection and the defendant's own taped statement, it's apparent the defendant is claiming self-defense. So you're going to hear a lot about self-defense. At the conclusion of the case, you're going to get all of the self-defense jury instructions. The question will be not whether or not this was an accident, because there's no evidence of that. It was an intentional shooting. Whether or not the defendant was lawful, whether or not he was justified in using that deadly force and killing Chad Oulson. Now, this is basically what the self-defense instruction indicates. The use of deadly force is justifiable if Curtis Reeves reasonably, okay, and these are going to be important words here, reasonably believed that the force was necessary to prevent imminent death, he was going to die, or suffer great bodily harm, while resisting an attempt to commit a felony upon him. In deciding whether or not the defendant was justified in the use of force, the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. The evidence will show you those circumstances at the time that the force, meaning the shooting, took place, was that another individual had tossed popcorn on him. The danger facing the defendant need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person, under those same circumstances, would have believed that the danger, and the evidence will show you the danger was popcorn was just thrown on him, could be avoided only through the use of that force. So the question for you will be this: would a reasonably cautious and prudent person that's 71 years old, because that's how old the defendant was, would a reasonably cautious and prudent person that's 71 years old, 6'2", 270 pounds, who's able to walk all around the movie theater, who has over 20 years of law enforcement experience, including 15 years on the Special Weapons and Tactics Squad, also known as SWAT, sitting inside a theater that by all accounts is going to be described as one in which you can see the environment, not pitch black like the movies, and not deafening loud, reasonably believe that the danger could only have been avoided through the use of shooting Chad Oulson. And the answer is going to be absolutely not. The evidence will show you there were some differences between Chad Oulson and this defendant on January 13th of 2014. Chad Oulson was 6'4". The defendant here is just 6'2". 2 inches difference. The defendant outweighed Chad by 65 pounds, but there was an age difference. The defendant was sitting an entire row back, an entire seat over. But the most important difference you're going to learn about during the course of this trial is that one of those 2 individuals brought a loaded firearm into a theater and shot and killed another person after popcorn was tossed on them. And that's this defendant. That's the one. At the conclusion of this case, we're going to ask you to find the defendant guilty of murder in the second degree. And we're going to ask you to find him guilty of aggravated battery. Not because we're asking you so, but because the evidence that you're going to see and hear during the course of this trial is going to tell you that that is the lawful and just verdict in this case. Thank you.
Thank you, Mr. Rosenwasser. Ladies and gentlemen, who's going to... Okay, we're going to take a break, yes. Mr. Michaels.